All right. Good morning, everyone. Thank you for joining us. We are excited to present to you the residential forms changes that will take effect in January of next year. I am Denise Cresswell. I'm the chair of the committee this year, and I am joined here by an amazing group of folks who have been such a huge help and support this year. Far left, Todd Scholler. He is with Smith, Scholler, Milliken, and Gallatin here in Nashville. And then there's Susan Barnett, the vice chair. She'll be the chair next year of the committee, and she's a broker with Crylike in Chattanooga. On my right, we have Addison Russell, and she is with Ramsey, Fair, and Bates here in Nashville. She's our general legal counsel, and she takes care of the legal hotline for us. She does an incredible job. And then we have Ron Poe, our special liaison, and he's with the Poe firm in Memphis. So we are so well supported on this committee, and I thank you all so much for all you've done this year. Your knowledge and your expertise is just incredible. So every realtor across the state know that you are so well supported by this amazing group of folks. Just some general comments. I wanted to also thank the entire committee. The committee is comprised of 13 people across the state, and they were an amazing group as well. Amy Cannon, Julie Casassa, Christy Hairston, Lee McWaters, Stephen Lamar, Diane Martin, Virginia Papafotis, Joan Smith, Joyce Smith, Vicki Trapp, and Carol Williams. And I'd also like to thank our executive committee liaison, Cindy Stanton, and offer a great, huge mega thanks to Sarah Selman, who is our staff liaison, and she was an amazing support this year. This information that you all have in front of you, the streaming, everything. Thank you so much for all your support this year. The committee met 8 times throughout the year and to discuss concerns that our members across the state had voiced, and a lot of these changes were from those concerns and from the hotline questions that folks would call in and ask. And so that's sort of where these changes originate. So anytime you all have any questions or any concerns or need some clarification, that's how you can voice your concerns, through the legal hotline, give the chair a call or whatever. But so that's sort of where a lot of this came from. Also, all the forms, we have, I think, 84 residential forms at our fingertips, and every single form this year was reviewed for clerical errors, for any misspelling, for anything that over the years some changes had been made, and maybe there had been just some things inadvertently dropped. So every single form the committee reviewed and corrected. So again, if you see some things that we might have missed, let us know. But we should be in good shape. For those of you who are joining us live stream on YouTube, thank you for joining us. You've got in front of you the same thing that we have here, this book, the table of contents. Just follow along with us, and you'll see the red text denotes deletions from the forms that we have been using. The blue text denotes additions. So just kind of follow along, and again, if you've got any questions, feel free to voice them online. Sarah's going to moderate, and then those questions will come up here so we can see your questions and address them as you submit them. So feel free to chime in. We'd love your questions. Okay, everybody ready?
Yes, ready.
All right, we will start off by introducing a form that we're really, really thrilled to have. It's a wire fraud warning form, And it's a document that we hope everyone across the state, if you're not already using one at some point within your company, we hope that everyone will use this one. Addison, do you want to review that one?
Happy to. And it's on page 7 of your books if you're in the room to follow along. And I think Sarah has it up somewhere, maybe. Unfortunately, a growing trend in our industry are cyber criminals, and they are hacking into the emails realtors are using to send false wiring instructions to clients. We've seen this on a national level, and that's why in 2016 we added the little paragraph at the end of the purchase and sale agreement saying never trust wire instructions sent via email, and we were hoping that that would do it. But we've recently seen a case here in Tennessee where this happened through really no fault of the real estate agent, but they were hacked and false wiring instructions were sent, and the client followed those wiring instructions. So we just want to highlight the issue, give it its own form, and really provide step-by-step instructions to your clients. Everyone should have their clients fill this out in all transactions, and I'll go through it pretty quickly, but it just tells them that this is happening. Cyber criminals are out there, and this is how they're getting to you. They're using phony email addresses. They're just sending emails directing you to a fake website or a criminal's bank account, and that your client should never accept wiring instructions from their agent. This also means that agents should not be involving themselves in wiring instructions. That should be communication from the buyer and their lender. It should not involve you. And so if a client is to receive such an email that looks like it came from their real estate licensee, they should not transfer any funds until they call the phone number used on all their prior calls, and that is with the lender or with their real estate agent. They call their closing attorney or agency or lender to verify, and then they can make a personal visit to the office. If they were to send wiring instructions by email or electronic means to anyone, do not transfer any funds until after they verify the correct instructions were received by a known representative at the financial institution. And then it goes on at the bottom just to say that if you suspect you're a victim, the client's a victim of wire fraud, or they received any suspicious emails, they need to immediately call their bank or mortgage company first. That needs to be their first step, and then call the agent that they've communicated with. So have your client sign this. This will protect you as a realtor to let them know that you have warned them that this is happening and this is out there. And then it will also hopefully protect your clients and make them aware of the issue, that this is happening and that they need to be on the lookout and be very, very careful before they lose hundreds of thousands of dollars.
Good. Any questions? Everybody good? This is going to be a very helpful tool, and like Addison said, it will protect us all and protect your clients. So we're happy to add that to our list of forms. The next form is the exclusive property management agreement. This is a new form also, and it sort of ties into another new form, the exclusive right to market for lease. Those two forms are completely separate. They do not overlap. The exclusive right to market for lease is not a property management form. It is specifically to allow a realtor to market a property for lease. And it lays out all the terms. It's just a marketing agreement. The property management agreement is a property management agreement for those of you who do some property management as well. But Addison, we had some task force throughout the year with folks who primarily do property management, and their input was invaluable to develop the property management agreement. And so Addison did a whole lot of work on both of these as well. So if you want to take those too.
Yeah,
Thank
I'm
you.
happy to. And we'll start with the property management agreement, and that's page 8 in your booklet. And before I start this is a tool that Tennessee Realtors is providing for your use. That does not mean that everyone needs to engage in property management. You need to be aware that if you engage in property management, you need to purchase a separate E&O policy, which will cover that activity. And you also need to be aware of all the laws and rules surrounding that activity. But we want to be beneficial to our members that are doing property management. And so we've tried to create a form that people can customize to make their own, because what that task force generated was everyone sort of had different ways of handling different issues. So the form is meant to be as universal as possible, and so that a firm can make it their own with their own existing policies engaged in. So just going through the property management agreement, sort of section by section, not too much detail. I'll try to give a broad overview. But just starting with section 1, after you get through who is the owner and who is the broker and the property address, this is the term. And it's just a basic term that can be for 1 year, 2 years, 6 months. But it does have an automatic renewal provision in it. And if either party does not provide written notice of termination 30 days prior to the end of the agreement term, the agreement shall continue and may only be terminated with 30 days written notice from either party. It also goes on to say that if the owner terminates without legally sufficient cause, they will owe the broker the monies due from the agreement. Section 2, leases. That's just your basic lease terms, the money that the owner is seeking at the rental rate, and then we have a provision that says, or such other terms are agreeable to the parties, and that's the length and dollar amount. Section 3 is the broker's duties. This is what you as a broker are expected to do in this agreement, and if any of this is outside of the provisions or the scope of what services you're trying to provide, you can fill that in special stipulations. But brokers authorized to negotiate, prepare, and execute all leases. Broker is authorized to provide his notice of termination. Broker is authorized to collect rents due. Broker is authorized to retain such amounts from owner's rental proceeds to pay expenses associated with the management of the property. The broker shall maintain a fund on owner's behalf in an amount agreeable to the owner and broker, from which certain expenses may be paid. And then going to page 9, upon commencement, owner shall remit to broker the sum of blank, again, a sum agreeable to both parties to be deposited as an initial deposit. And this is what the broker can pull from to pay those operating expenses as needed. Broker is authorized to negotiate partial refunds with tenants upon certain circumstances, and then broker is authorized to make arrangements on owner's behalf for any repairs that will not exceed a certain amount. So you could put $100. If a tool is overflowing and a valve needs to be replaced, the broker can do that without having to get permission each time. But if it's a major repair, then they would have to get permission from the owner. And then brokers are authorized to charge tenants administrative fees. And this can be for processing applications, handling security deposits, what have you. Next, we'll move on to the owner duties and representations. And here we sort of did a checklist. There are some basic things that the owner is responsible for, making sure the property is habitable, that they're up to codes, that they have title. But then we have a checklist of items which are negotiable between the broker and owner. And that's who is responsible for winterizing the property, if necessary, utilities, and who will pay that utility balance. And then it says owner shall provide funds to broker promptly upon broker's request for any expenses. Again, this is a check mark. Owner is responsible for lawn care services and pest control services. So it will depend on if the broker will handle that, maybe the tenant will handle that, or maybe the owner will handle that. So just keep those check marks in mind. If they're not checked, they're not part of the agreement. Then we go to section 5, the compensation section. We have a few ways that a broker can choose to get paid, either upon occupancy by a tenant, all at once, or upon monthly payment of rent, they can get a flat fee or a portion of that rent coming in. And then I think some people like to have a flat fee up front for their services performed, and also to get that initial deposit, and then collect a monthly basis from there. So maybe you want the first month paid to you as a broker, and then you're going to take a portion of the month's rents coming in. Any compensation obligations will survive termination of this agreement. Section 6 is just filling out the homeowner condo association information, so the broker will know that information and who they can contact. Section 7 is properly insuring the property from the owner to cover the activities which will be happening and to name the broker as an insured. Section 8 will be pets, and here you will check if the owner is allowing pets or if they are not allowing pets, and then what that pet fee will be, a maximum number of pets, a maximum number of pounds per pet, and then also information regarding service animals and the owner's obligations related to those. Section 9 just says broker is authorized to accept from tenant all rents, security deposits, and pet fees, and how that they will handle those monies received. There are some lines to fill in that broker shall distribute to owner any rent and fees received as follows, and that can be on a monthly basis, a quarterly basis, an annual basis, however you choose. Section 10, we have our agency paragraph, and we sort of simplified it from what you'll see in our listing agreements. It's geared toward practicing designated agency, and it allows for a firm to appoint a designated agent, and then should something arise, they can appoint a subsequent designated agent. This highlighted portion is just taken from agency law, and these are duties that are owed to all parties in a transaction. Yes. And then we just really get into the legalese, section 11 on down. I won't bore you with all of that. It's the standard is in all of our other documents, and that's there to protect you as a broker and to protect all parties involved. And then, like I said, there is section 15 special stipulations to make this yours. And so just for clarification, that was form what we're going to call RF 171, which is the property management form. And now we'll move on to RF 172, which is the market for lease. And I think Denise can give an intro as to how this form came about, and then I'm happy to describe it.
Okay. Yeah, there was, this will be Form 171, the property management's 172, right?
Mm-hmm.
Backwards. Okay. All right. That's right, backwards. Thank you. The property management form is 171, and the market for lease is 172.
Is that right, Sarah?
Yeah.
Okay.
Yeah. This form, the exclusive right to market for lease, was suggested because there are folks out there who are putting properties in for lease, putting them in their MLS for lease, without any documentation, without any protection whatsoever. And it's happening, so we needed to address that, and we needed to have something in writing, an agreement between the realtor and the homeowner, that they have this agreement. So another task force was brought about, and suggestions were given. There were some folks who had some agreements already, and so this collectively was brought about and discussed and vetted. So that's where this came about. Now, it might be a situation where if you use this form as a lease only, a marketing agreement only, but you also agree with that owner to follow through the whole way through and manage that property, or help him lease that property, physically lease it. You have that ability through special stipulations. You can tailor this however you want to tailor it, or however your broker allows you to tailor it. So that's kind of where this came from. if you want to.
Yeah, and starts on page 15 of your document. Yes, sir.
Is this a brand new form?
Yes.
Brand new.
So how are it's got the blue says are additions. It was
Yes.
an originally created form.
Well,
and then,
And that really should be in all black since it's
Okay.
all new.
Yeah.
That you'll see that this is a working product of the committee, and so
Okay.
what's in blue here were things I think added at our last meeting.
Mm-hmm.
And so at the time they were new to the committee as consideration, but
We went through several versions
yes,
of it. So,
we did.
Yeah.
For your purposes, though, it should all really be in all black, and it's a brand new document. It's a good question.
Yeah.
So starting on page 15, and I think Denise did a great job explaining it and how it should be used. And I've gotten a lot of questions on the hotline lately of what form do I use if I want to put a property in the MLS for rent? Well, now we have one. So again, this is not a property management agreement, and I've spoken with an E&O provider regarding this, and if you're just listing a property for rent, you're not engaging in property management. So that is covered under your regular policy. You may want to double check with your specific E&O provider regarding that, but that is an activity listed in the Brokers Act. So again, we'll just go through section 1 is the term, and it has the lease term, and then it also provides when the property will be available to a tenant to occupy. Again, it says if an owner terminates the agreement without legally sufficient cause, owner will pay broker the compensation due under this agreement. Owner authorizes broker to advertise a lease period of however many months at a rental rate. There shall be a security deposit, and then we go into section 4 talking about pets, and it says owner authorizes broker to advertise pets are allowed, to advertise pets are not allowed. And again, what that pet fee is, the maximum weight, the pounds, and talking about service animals. We just really wanted to we want the broker to have as much money as, as much information as possible before you put it into MLS. So that's what these sections are for, that you can have all the pertinent information to advertise to a possible tenant so they know what they're getting into. Section 5, broker's duties. And you'll see we really tried to limit the broker's duties. This is a marketing agreement. This isn't really an agency agreement. So broker's duties, they're specifically say what broker shall not be responsible for. And unless this is agreed otherwise upon writing, and if you're engaging in these activities, I would encourage you to use the property management form. But a broker using this form will not be responsible for negotiating a lease agreement, advising the owner on which forms they should use, such as leases or other documents as may be necessary. A broker won't conduct a background check. They won't order a credit report. They won't handle application fees. They won't hold security deposits. They won't review employment history or contact reference. They won't evaluate tenants for you. They will put your property on the MLS or other avenues to advertise it for lease. Now, a broker is authorized to receive notices on behalf of the owner and to show the property. Section 6 is the owner's duties. And again, these are some generic things such as the owner has title, the property is habitable, they'll cooperate with the broker, and they'll make the property available for showing. What you will see in blue there, and I will highlight this because it seems sort of odd, but it says that the owner may not expect or seek assistance from any other licensee in the transaction for the negotiation of a lease, guidance on forms, procedures, and steps which may be needed. And this comes from the Brokers Act and the agency law. And since this isn't an agency agreement, these are things that have to be waived in writing by a customer. So this will satisfy that requirement pursuant to the law. And then it goes on to say that the owner is offering the property by abiding by the fair housing statutes. And lastly, you'll see there in the event the property is currently leased, the owner is warranting that the property is available to show to prospective tenants under their current lease agreement with their tenant. and that the owner shall be responsible for notifying those existing tenants of any showings. Section 7 is the marketing agreement. This is very similar to what is in our listing agreements, which is authorizes you to market the property. And then Section 8 is the compensation. You can do a one-time compensation, which shall be due and payable upon a lease by the tenant or execution of this agreement. Some people just want to be paid up front to put it up, and then, or other people, much like selling a home, you get paid once the home is sold, and then here you'll get paid once a lease is executed. Cooperating compensation, page 17, section 8B, this will allow you to provide cooperating compensation for someone representing a tenant. And then we have the carryover clause, again, very similar to our listing agreement. If the property is leased within so many days after expiration of this agreement, a broker can still be paid. Section 9, again, is the homeowner condo association information, so you have that information to market. Section 10 is just the condition of the property and the insurance requirements of the owner. We'll move into the agency paragraph. Again, practicing designated agency, the appointment of a designated agent, the ability to appoint a subsequent agent, and then the ability to default to facilitator in the event a broker represents the owner of the property and then also the tenant. And then D, that resumption of agency status once the facilitator status is no longer needed. The highlighted portion here are just those statutory duties owed to all parties in a transaction. Again, this isn't, this is just what you owe to all parties in a transaction that comes straight from state law. You can ignore the red there. We had a lot of, like Denise said, we had a lot of working documents throughout this, so I apologize for any confusion that maybe this creates, but just that's sort of from our listing agreement. We tried to simplify it for the purposes of this agreement. From here on out, it's legalese, and that's the same legalese you'll find in all our other documents. So, yes, Nia? Yes.
I mean, I see that you put in and you put out this in the event the owner decides to sell the property. Is that anywhere else?
No, we had a lot of discussion on that, and I think the committee just decided that if the owner wanted to sell the property, then they can enter into a listing agreement with that agent, or we didn't really feel necessary that it was necessary to tie them to that agent. They had enlisted to just list their property for a lease. You know, we didn't want to tie their hands necessarily, I think was the consensus.
Mm-hmm. Okay. Any other questions about this document? All good? Thank you, Addison. That was a lot of work this year, pulling those two documents together, and so thank everyone for all your work with those. The next form is the RF 101, the exclusive right to sell listing agreement, designated agency. And Todd, if you would take the lead on that one.
Well, this form has been worked on for many years. It's actually in pretty good shape. And so the only real change that we made to this one is on page 3, I guess it's page 26 of the documentation that you have in front of you. Down under section 9, having to do with some hold harmless language and authority and responsibility of the broker. The language starting there on line 149, seller is responsible for compliance with state and federal law regarding usage of video or audio recording devices while marketing or showing the property. Seller should seek legal advice regarding their rights and limitations related to their actions. And, you know, videoing, security systems with the all the smart technology and all of that has gotten to be a bigger issue. Trying to ride herd on that and keep track of what those laws are and how they may be affected, and not knowing sometimes what sellers do and do not have in a house. We are simply trying to shift the responsibility here to the seller to say, look, it's your responsibility. You know your technology. You know what you have in the home. You have to abide by the law. And if you don't know what that law is, then you can seek legal advice as to whether or not you can or cannot record or do certain things with that technology. But that's not an area that a realtor should be expected to either be responsible for or to give advice related to.
Do they have to disclose?
Does who have to
Do
disclose?
we have to disclose that there are those?
See, that's the thing.
In MLS?
You get different answers from different people, and that's part of the issue. Some MLSs have introduced fields in their input information for whether or not there's technology, video recording, and so forth. Some MLSs have not. You know, the law in Tennessee, videoing is looked at differently than audio recording, and you get into the nuances of, it's a lot more problematic to record audio than it is to record video. So I think the short answer is, it's always best to disclose. If you know that there's recording, then I would recommend that you disclose it, but sometimes you simply don't know as the realtor.
Even those new Ring doorbells, right there.
Right, right.
So are you advising us to advise our agents that if they know they have something like a Ring doorbell, that they should disclose?
I think, look, in my opinion, and this is just my opinion, it's always better to disclose. And that way it removes any expectation of privacy and clarifies that, for any potential buyer. But again, sometimes you simply don't know. And so the job here was just to simply put this over onto the seller to say, look, it's your responsibility. You're responsible for your actions insofar as these activities go. But my personal opinion would be that if you're aware of it, to disclose it.
As an agent?
Mm-hmm.
What if Susan asked, what if the seller says, hey, don't let anybody know that we have this?
Well, again, it depends on what the technology is, I think. Video recording, I don't know that people have an expectation of privacy when you're in somebody else's home, to privacy in terms of being able to monitor. But it's a whole other thing to record audio. You're not a party to the conversation. And so I think that's, and Ron may want to weigh in, I don't know. To me, that could run afoul of the law, recording audio.
Mm-hmm.
That's a different.
The rings are audio and video together.
Yeah. So.
So from an MLS standpoint, should it be original marks?
That's what I would do if it were me. If I had knowledge of that, and again, I guess this is something else that maybe is a bigger question that we can look at, but I always like to disclose if I have knowledge, and that way, but I would advise my sellers against audio recording. That's just my personal opinion, because I don't think anything good can come from that. What are you going to hear? And it kind of puts you on treacherous ground, I think, legally.
But
So.
then she just said, like with the video, it's audio in that as well.
But some are, but some are just purely, the nanny cams, sometimes they're purely video. So I think what we just talked about sort of illustrates the point. There's such different technologies that people use. I don't know what their technology does or doesn't do, so rather than me have to worry about it, I'm just going to put it on the seller to go, look, abide by the law. And if I have knowledge of something, then certainly that puts it in your realm where you're going to have to think about, should this be disclosed, and must it be disclosed? But in a lot of cases, you simply don't know. And so that was the goal in this case, was to simply make them aware that it's their responsibility. So. Yeah, and this is all in that hold harmless section, by the way. So that's, to hold you harmless and indemnify you against loss related to their lack of disclosure or their improper use of that technology. So that's why it's there. And that's basically it on that form. So.
I guess mine will
like if they choose not to disclose, even though they're supposed to, and we have knowledge of it, and we know it's there, and we put it, I mean, it's kind of a sticky situation
Mhm.
there.
Yeah, because
So we
we're
cover our
only
butts and
required to
put it in
disclose
it.
adverse facts that we know. Is that an adverse fact?
Well, I don't know if that's a debate for now or.
No,
Or
I'm
for
sure
later.
this could go on for quite some time. but
Yeah.
At least we're starting.
Mhm.
I'm sure this is gonna get, as time goes on.
I promise you, we had a very healthy discussion about it
Oh, I
also.
can
And there-
imagine.
So,
You know, there are, maybe there are other things that need to be looked at in terms of either provisions in forms or possibly in the MLS rules about how to handle this sort of thing.
Because it's gonna get.
It's only gonna
Yeah.
get bigger.
Exactly.
And,
Absolutely.
you know, from a forms committee standpoint, we're trying to shield you from liability
Mhm.
more than answer the big picture of, you know, adverse facts and disclosures
Right, I'm sure.
There are
necessarily.
companies that are doing that already, that giving people public access to the homes, and they've got video cameras in there.
Mhm.
Um,
And that's disclosed in the remarks? or-
I don't know the exact process. I think it might be open door or something that there's where they
Mhm.
can, the public can just go and get in themselves.
Right.
But agents can show it as well, but they do monitor the homes with video.
Yeah.
Mhm.
I would, and I'm not familiar with that, I would be surprised if they have any audio recording. I think it's, but,
I think they do.
because I think that's on a whole different spectrum than just, you know, video, making sure somebody doesn't do something improper at home, that's one thing, but to listen to their conversations, you're not a party to that conversation, you know, and so you don't have the consent. And so I think that could be a real problem area, frankly.
And this may be a topic that you'll need to address again next year, as this just continually evolves. But it just needs to be addressed. So thanks, Todd.
Mhm.
The next form is the RF 102 exclusive right to sell listing agreement, seller agency, and Susan, if you would take that.
Thank you. Good morning, everybody. Again, this is the RF 102, the seller agency listing agreement, and all we did is going to be on page 36 of your handout. You'll notice the red language that has been stricken through there. Assignment of designated agent, you can't have designated agency in traditional seller agency. So we just cleaned the form up there. That's basically all we did on that form.
Okay. Thank you, Susan. And then the RF 132, lot land exclusive right to sell. If you'll take that.
Okay, RF 132, look at page 44 of your handout. And it is exactly the same that we just went through on the exclusive right to sell listing agreement. This is the lot and land exclusive right to sell. And we took out the designated agency language there also, because this is the single agency or traditional agency form.
Just a little cleanup.
Just cleaning up, that's
Yeah.
right.
Thanks, Susan.
You're welcome.
Next, the RF 142 exclusive buyer rep agreement. No.
141.
141 exclusive buyer rep agreement designated. Hey, Todd? that
Yeah,
would be
that's-
you.
You just added this
Yeah, look at, on Form 141, exclusive buyer rep agreement, look on page 51, and it's letter E. And this is where we're advising buyers of the likelihood or possibility of video recording. Buyer hereby advises buyer the possibility that some properties may utilize security devices that record physical movements or audio conversations. Therefore, buyers should limit making comments concerning the value, features, or condition while viewing any property. So just trying to balance it out, to put buyers on notice that, look, these things are there, so just be mindful of that. Most of you guys probably, you know, would advise them of that anyway, but this just kind of puts it in the documentation to say that we did. So, and that was it on that form.
Good. Any questions? Thank you, Todd. RF 142, exclusive buyer rep agreement buyer agency, and that would be Susan.
Okay. The change on RF 142 is going to come in on page 57 of your handout. Again, it is just the removal of the designated agency language.
Okay. And then the 144, non-exclusive.
Okay, that's going to be on page 62 of your handout. This is the single agency form, the non-exclusive buyer representation agreement, RF 144. Lines 131 through 135 is the removal of the designated agency language.
Good. That's it. Thanks, Susan.
Welcome.
Okay, the next form is the RF 151 listing agency mutual release agreement. That's on page 65 of your handout. The only thing we changed on that one was on line 17, where there's sort of the holdover paragraph, if you will, starting on line 9. What we added was, this paragraph shall not apply if the property is listed with another licensed real estate broker at the time of such contract. I think it's always been assumed that if the release is put in place, that was the case, but now it's written that the holdover would not apply. So that was the only change on that one. The RF 401, the purchase and sale agreement. We had just a few items of clarification on this one, but I think what was changed will be helpful in terms of being a little bit clearer and more open. And speaking of open, on line 16, I'm sorry, page 67.
67.
That's a purchase and sale.
Yeah,
Okay.
yeah. On line 17, we just made openers, garage door openers. It could be plural, singular or plural.
And on that note, an opener
Yeah.
So we
is,
skipped the property, we just said that's something we can understand. You
Huh?
skipped the property condition disclosure change.
Oh,
I'm following in this book, I'm sorry.
no, that's fine. Did we skip?
We'll get to that later.
Yeah, we're
Okay,
gonna address
oh,
that later.
I just tried to follow.
Yeah,
Yeah.
I'm sorry. We've got another
We're
list.
grouping a few things with the
Okay,
disclosure.
I'm sorry.
No, you're good.
Okay, so we're on 401.
Yes,
Yes.
401.
Page 67.
Okay, got it.
and
Thank you.
so an opener is that thing at the top of the garage that actually operates the garage door.
That the
A
electricity goes
remote
to.
is what you use to open the door. So that's just a distinction that we're trying to educate everyone about. I think the remotes are listed on, you'll see right here, after opener, at least blank remote controls. And so that is the difference in what an opener is and what a remote is. And we changed that to plural because you could have a 2-car garage, 3-car garage, etc. And that's how many openers will be there.
And there is confusion about that. So, yeah, hopefully that'll help a little bit. Then on page 68, where we address the type of loan that the buyer will take out, we added a couple of different types just to be more specific. We added the THDA and the Rural Development USDA loan. Instead of just leaving other so generic, it'll be nice to have a little bit more specific so everybody knows from the get-go what the loan type is going to be. Then on page 69 at the bottom, line 152, again, just for more clarification, we added the closing agency for buyer and the contact information. So we, as agents are filling this out, just to have that contact information there in the form will be helpful for everybody working on this.
If I could just interject, this falls hand in hand with the wire fraud.
Mhm.
If you make certain that this information is included in the purchase and sale agreement, that has a base by which the clients can work from, because they're there when they're signing it, and not looking at someone else's email for their for a phone number.
Yeah,
Thank you, excuse me.
that's a good point. No, thank you. On page 70, line 205, there is a greenbelt paragraph that we added, and it's also added to the 404, the land lot. But this just basically specifies and allows the buyer to note on here whether he or she intends to maintain the property in the greenbelt classification. And if they do, then they need to understand that their failure to make application will result in the assessment of rollback taxes that they would be responsible for. So they just need to understand what their responsibilities are if they intend to keep it as a greenbelt. And we just made that as specific as we could.
So that's an in-office training class on what the green belt is and
Yeah.
what that actually is all about. Because unless you're if you're selling houses in subdivisions all the time, that's not going to mean a lot. But for
But
the
if
folks
it's
that
15
are,
acres or more.
Mhm.
So it will be an education, but we went ahead and put it in here because it does apply in a lot of cases across the state. And
So the buyer has a choice?
Yeah, the previous language just kind of had an indication, do they intend or do they not intend to keep it in the greenbelt, but there was not really anything beyond that to say, well, what if? Well, it makes a big difference to a seller as to whether or not it's going to stay in the greenbelt. If it's not going to stay in the greenbelt, then the seller is going to be looking at 3 years of rollback taxes. That could be a considerable sum of money that they'd have to pay. They need to know when they're contemplating this contract, this offer, what the status is going to be here. Because if the buyer doesn't go or changes their mind midstream, it could really change the deal for the seller. So we're trying to make the buyer elect and be very clear about their intent so that everybody knows going forward what's going to happen. But yeah, it is an election that can be made. It may be that the buyer intends to change the usage and therefore they don't intend to keep it in the greenbelt, and that's negotiable and that could be agreed upon, but you want the seller to understand that because that's going to change the deal for them.
So then it's on the seller instead of the
Yeah.
No, it's on the seller by statute.
Right.
So if it's unspoken, then the seller is obligated for this greenbelt tax that could evolve. So as Todd points out, you want to try to flush this out at the time of the agreement. Well, it's when it's a change of use. If you go from say it's greenbelt, agriculture, and then the individual says, I'm going to subdivide this land, well, you'd lose that greenbelt. But the seller may think they're selling their home in that 15, 20 acre tract with the barn on it, and it will continue greenbelt. And they need to know that. So if you're dealing in land, more than 15 acres, it's just something you need to get up to speed on and understanding greenbelt, what types of properties qualify for it, the ramifications if it's not addressed in the contract, who carries the responsibility following closing.
If it closes and then they change it, the buyer's, it's up to the buyer. If it's already closed and the buyer changes from what they intended.
Yes,
I think, Bobby, in that situation, and Bobby asked what happens if the buyer changes after closing, who's responsible? But per statute, the seller would take that tax hit, but then they have a contractual agreement with the buyer where the buyer said that they intended to keep it in the greenbelt. Now, it depends on how, the time limit following closing when that happens. And I'm not sure on.
Is that the statute with limitations of 6 years?
No, well, back to that point, no. What we're talking about is that by law, that when the property has a status of greenbelt tax protection, it gets a much less reduction in taxes. And that can keep going year to year. But when you sell the property, then you have until, I think, the end of the early spring of the next calendar year to go ahead and give notice that you wish to either keep greenbelt If you do not apply for Greenbelt, continuation from the buyer's perspective, it automatically reverts back to loss of Greenbelt. Then when it reverts back, the government's entitled to collect taxes for the 3 prior years at the rate it would have been if it had not had Greenbelt. And that's what I'm saying. The seller would be responsible for that by tax, by law, unless you address it. So what we're attempting to do in a way is to get people having communication about this and the cost that would be involved. Some people are going to keep a Greenbelt, some people will not. But you need to at least attempt to bring it out in the contract.
And then once that buyer makes that application, then the buyer is now the listed owner of that property and can handle any ramifications going forward. But if they fail to make that initial application, that's what happens.
That's a big.
Yeah.
Well, if you're working in rural areas like some of us do, we've been dealing with this and,
But even in
well,
anywhere, there's
Mhm.
developers and all this.
right.
Yeah.
In the development world, it's big.
Huh?
In the development world, it's big.
It's big, yeah.
Right.
And there is an informational, I guess a white paper,
I guess that's what it's called.
yeah, in our forms that explains what
Okay.
Greenbelt is. So, yeah, that'll be helpful for a lot of people that don't work in that very often.
And where is the one, it's
So
in the.
it's on Forums on the Fly on tnrealtors.com. And it's an informational sheet.
And what is it called?
Uh,
I was trying to look back.
Well,
I don't know what the
if you
name-
search Greenbelt and Forums on the Fly, it will pull up.
Mhm.
There, I think Susan is doing a quick search now.
Also notice the
Yes.
little caveat there that the buyer should consult the tax assessor.
Mhm.
You know, because it's not always immediately apparent, you know, what the usage needs to be to fall within that. And again, we're trying to avoid you having to opine about whether it can or cannot stay in the Greenbelt, depending upon their usage, so.
It's located, right now, it is attached with the RF 404 lot and land purchase and sale agreement. Do you think we need to push it up
I think it
since
needs
we
to be
put
separate.
in?
Yeah.
Okay.
But what's the title of it?
Well, yes, that's a good idea. Oh, I can't see, it is Greenbelt, a Tennessee Taxpayer's Guide. So I searched Greenbelt and it came up that way.
Good,
Good job.
thank you. And again, this is obviously going to be on the 404 as well. Okay, the next change is on page 71, line 252. The association lien payoff in the event the property is subject to mandatory association assessments or other fees, which may impose a lien, the seller shall cause to be delivered to buyer or buyer's closing agent not later than 7 days before closing a lien payoff, estoppel letter, or a statement of account reflecting that has been paid, to bring the account current. That way there's no surprises right before closing, hopefully, at least not related to a lien payoff. Oh, I'm sorry. Oh, yeah. And then on line 257, where we address the lead-based paint disclosure, you either check it does apply, it doesn't apply, or it does. But we also referenced the lead-based paint disclosure, so that if it does apply, everyone knows that there is a specific disclosure that needs to be.
And per statute, that has to be attached to the contract, but that is the only thing you should really be attaching. Like, the property condition disclosure does not need to be
And we
attached to
don't
the
have to
contract.
restate that in the notice.
Exhibits and addenda.
Right.
Right.
But per federal law, the lead-based paint disclosure does need to be attached to the contract, and so that's why that language appears. And then you'll see that items not selected or not part of this agreement was removed because the lead-based paint disclosure is the law, so just because it's not checked doesn't mean it doesn't apply. It always applies.
Yeah. Okay, good. And then on page 73, there were just some, a reference to, on line 324, there's a reference to section 7, so we corrected that to be consistent with the rest of the verbiage. I'm sorry, yes.
Yes. This is a question from someone that's watching online,
Mhm.
and this is their question. I'm going to read it.
Okay.
When we get to the repair section, please ask, number one, how soon after inspection do they have to send repair proposal? That's question number one. And number two, can they wait until day 3 of the 5-day resolution period to send the proposals? And that's, I'm just reading a question that someone that's watching online is
Our
asking.
suggestion would be go to the next forms class.
For sure.
Yeah, you want to take?
Oh, well,
I mean, it,
so there was a question from a viewer about a repair timeline, proposal timeline, and not that it wasn't a great question, it was, and they can call the legal hotline and I will answer that for them. But I think for today's purposes, we sort of just want to stick to the changes of the forms, because we could be here all day, and I've done that many times before, and I'm sure everyone in this room has, going over the 401. So I would just encourage them to call the hotline. I'll answer it today, and then, but we can stick through sort of the changes, not to bring any confusion to the rest of the viewers.
thank you. Thank you. On page 74 of the purchase and sale agreement, line 407, we worked really hard to try to clarify exactly what the binding agreement date means. That has been a point of confusion for a long time, since binding agreement date was ever put into the purchase and sale agreement. So we're trying to clarify that, and hopefully this will help, and then we've got another change to it as well. But basically, the binding agreement date is there to give clarification on when the timeline starts for time-sensitive matters. As we all know, an agreement has been received and is a contract when that agreement is received by the party who's received the fact that the last change has been acknowledged and received. That's when it becomes a contract, a drop-dead contract. The binding agreement date is only there for purposes of time-sensitive matters. So, with that, there's verbiage that has been put in here. The foregoing time and date will be referred to for convenience as the binding agreement date for purposes of establishing performance deadlines. And we redlined the rest of that just because we think that what we added should be clarification enough in terms of what the binding agreement date does.
Yeah, and then what you did, add in, makes real sense on page 77.
Right, and then at the very end, on page 77, just for further clarification on line 541, we're calling, instead of calling it the binding agreement date like it has been called, we're calling it now the acknowledgement of receipt. And that should hopefully clarify that the realtor who has received that final signed document and is accepting that final signed document, they are acknowledging that they've received it at that point.
Well,
Well-
sure.
Stay tuned until next year.
Yeah.
I think this is really good.
Yeah, and then it says here on 542, the realtor signs, dates, and this shall be referred to as the binding agreement date for purposes of establishing performance deadlines. So that's what the binding agreement date, that signature is acknowledgement that it has been received.
What happens if the agent waits a day or two to sign that?
You still have a contract.
Yeah.
Right, so kind of. it's
You
really-
just-
You have to reference the delivery, right?
Yes.
The delivery would constitute.
You have to look back at what notice.
date.
It's
You might
receipt.
keep in mind that there has been a misconception in the industry for several years that a lot of agents felt that until the binding agreement date at 542 was actually inserted, there was no contract. So the intent here is to get it clear that the contract arises when someone makes an offer, other side makes acceptance, but then you have to give notice of acceptance, and that's where we're using the word acknowledgement of receipt. It's notice of acceptance has to come back so the parties then know they're bound. And of course, by our purchase and sale agreement, we allow agents to accept notice for that one purpose. So it's not like having to get it on to the buyer or get it back to the seller. So that's when it occurs. So we're trying to get over that hurdle first, that there is a contract as soon as there's offer acceptance and return with receipt. Now we get into these performance deadlines, and did they receive it tonight at 10 o'clock by email, or they open their email at 8 o'clock in the morning? There's other things that you have to address, but then you fall back that agents by the Brokers Act have responsibility to act in, due diligence and do things properly and not time and let something sit around for 3 days. I would say the agent would have a problem if they waited 3 days to insert the date.
Right, but I'm sorry, let's be real. But depending on which side you're on, obviously, but if the agent does wait a day or two, my question is, if I can show, and I'm trying to stick to the deadline, if I can show delivery to that agent, that would be when I would say they received it. And that would be the date that I could go off of if there was a discrepancy.
Interesting point. I think by definition of agents co-oping, they also ought to communicate.
Yes.
Oh,
Yes.
And communicate with each other. Hey, I've sent you that. We're under contract. Will you go ahead and insert that date and send it right back to me? And actually talk to each other. It's an amazing mode of communication.
yeah, I agree.
But we had that problem already with the binding agreement date the way it was. Same thing applied then. What if they don't give it to you for a day or two? So what have you been doing when that happens now? I mean, we're just calling it something different, actually, that way, so.
But he makes a great point, but what do you do in that situation if no one is responding within
Well,
1 or 2
hopefully
days?
the broker can send them down and find a date where everybody can start working with.
But
Well,
I
I think
think
that you have to
showing-
refer back to your
Right.
To your delivery,
right.
And
what
that's
you-
in the
So when it-
notice paragraph.
And when it hits your
Yes.
inbox, you've received it.
Right.
Right.
You open it.
Whether you open it or not.
Right.
And if you have an agent that's not cooperating and working with you to acknowledge that, there's steps you can take. You can go ahead and say, I've made 2 requests of you to insert the binding agreement date as November 8th and have not had a response for the purposes of moving forward. We're deeming it November 8th as the day it was delivered, evidenced by the email where I sent it to you. And by the way, I just copied your broker.
And if you'll take a look at line 402, which is on page 74 of your handout, this is a line that's been in there for a while, because we get this same question over and over. I know I do when I'm instructing the forms. It says there that it's hereby agreed by both buyer and seller that any real estate agent working with or representing either party shall not have this. Well, that's not what I was looking for. What happened to our sentence there? Oh, did we take it out?
Oh, gosh.
No, it's still there at 406.
406?
What are you looking for?
Oh, I'm sorry, it's 406.
Yeah.
The parties hereby authorize either licensee to insert the time and date of receipt of the notice. So either licensee could go ahead and do it. I'm sorry, that's what I was looking for.
Either.
Either one can. So if you don't get it for a day, then absolutely do what was being said. Notify the broker and say, I've inserted it and here's what we're going by. And you're a day behind already, or 2, or you get there. I was like, I've lost that line.
So that should only be used in a worst-case scenario if they're not responding.
Sure.
Yeah.
But technically, based on the way it was worded before, if you wrote an offer for one of my properties and my seller or buyer, whatever, accepted it, I send that to you and then you sign it. That's the way it's supposed to be.
That's in the perfect world of real estate. Yes,
Of course.
absolutely.
Okay, I got you. But in the event that you didn't respond, then I can revert back to line 406 and go ahead and insert.
Yes. And then make sure everybody's on the same page with that date, because that's when the timelines will all start.
And if you have evidence that you delivered.
Right.
Mhm.
Yeah. No, those are good questions.
It's been confusing for a while.
It has, yeah.
Could you tie the blank space in the notification form to that? I'm signing this, but I'm notifying you that this has been signed. What is that, like number 12 or whatever on notification? It's in other, yeah.
Yeah.
I
just
just
other
don't think
generic.
it's gonna be
Doesn't
easily adopted.
I think you could use that.
You can use it, yeah, in with any situation,
Yeah.
but, yeah,
Just be a paper trail.
Right.
Yes, you know. just-
True. That's true. Good point. Okay, any other questions about this so far? On page 74, there were just a couple of minor references that were changed to sections versus paragraphs, so nothing major there. On page 75, under 15, seller's additional obligations, basically, we just restructured this paragraph so that it's a little bit more user-friendly, because these are very important items that need to be addressed. And they reference any disclosures required by law and what the seller is required to disclose. So basically, we just reworded this so that it's a little bit easier to, yeah, to review with your clients. And as far as the purchase and sale agreement, we discussed the binding agreement date and the acknowledgement of receipt. So that's all we have for the purchase and sale agreement. Any questions? Good. Good, good. Well, it is a little after 11. If you guys, we can take a 15-minute break, and then we'll be back in just a few. Is that good? Welcome back, everybody. We're going to continue on. We've got a few more forms to review. So we left off with well, let me go back for just a second before we dig into this. One point of clarification, the wire fraud warning document, the brand new document, will be ready for use today. All the other changes to the forms that we're making will be effective in January, but because this is such an important issue that needs to be addressed immediately, that document will be online and ready to use by this afternoon. So just remember that. The other forms will be ready in January. Okay. All right. Let's go on to RF 641, the real estate offer confidentiality agreement. This is just a very minor change on page 78, line 1. This is an agreement of confidentiality between the owner and the realtor before any offer has been made, so we don't need date of offer. So we just took that off. That's all for that one. And then the RF 481 on page 79, earnest money, trust money disbursement, and mutual release. Susan, can you take that?
Sure. RF 481, the changes that were made there were on page 79 of the handout. We changed the title from earnest money, trust money disbursement, and mutual release of purchase and sale agreement to mutual release of purchase and sale agreement and disbursement of earnest money and trust money. We felt like it was being ignored a little bit, or people didn't know how to release agency as far as that goes, and you can do that with this form. And we added a line at line 15, earnest money, trust money shall not be dispersed prior to 14 days after deposit unless written evidence of clearance by a bank is provided. And that comes from the same language that's in the purchase and sale agreement as far as earnest and trust money goes. And I believe that's all for that one.
Yeah. Yeah, just a little clarification. Thanks, Susan. The next is RF 627, and that's a temporary occupancy agreement for seller after closing addendum amendment, page 82. Just a little bit more clarification here on line 19. When we're addressing the possession transfer inspection, we took some verbiage out that seemed to be a little confusing. Again, this is temporary occupancy agreement after the closing has taken place. Buyer and seller, on line 19, buyer and seller are encouraged to engage in a walkthrough of the property at the time of transfer of possession to confirm the condition of the property. The verbiage that was in there, and not their real estate agents, we took out because some clients want their realtor there just as backup, and because they went through the entire process. So that was a little confusing to some. So we took that out, and hopefully that's a little bit clear for some folks. They have the ability if they want it, if they want their agents there. And then we took out a list of damages to the property. So
I know we could put it in special steps, but is there a discussion about like holding money, you know, or anything like that in any of the conversations? So that if they do get into a situation where there are damages, they're not having to track down the seller to get money to pay for the things. I mean, there's nothing in there regarding that. I mean, not. I'm just curious if has there been any discussion in the committee about that?
I think, correct me if I'm wrong, I think we removed that, did we not, a couple of years ago? And I guess the thought process was to make these agreements more between buyers and sellers, and not embroil the agents in the holding of money and escrowing of money and that sort of thing. You know, speaking for my industry, it's very problematic to escrow money, and it's, you know, to hold money for these types of things. You know, sometimes lenders get involved. They don't like money to be held that might flow back to, I mean, so the goal was to basically say, look, if there's going to be a deposit of any sort, you guys sort it out. Because our representation and our involvement, technically it ends. You know, it's closed. That's where our obligation stops, and all this other stuff beyond that is really in the legal realm of, you know, did they leave the place damaged, and then, you know. So I think that was the thought process. Now, you know, whether everybody agrees with that approach, I don't know. But again, you can address it in the other agreement section in the special steps, but I think that's why we removed it a couple years ago, so.
Okay, the next form is RF 653, Amendment to Purchase and Sale Agreement. This, again, is just to simplify the title, Amendment blank to Purchase and Sale Agreement versus Amendment to Purchase and Sale Agreement, Amendment blank. So we just flip-flop that just for ease. So that's all for that. RF 655, page 86, the repair replacement amendment. Line 25, seller agrees to complete the above matters blank days prior to closing as provided in the agreement. And then we reference completion of repairs deadline. That's what that period is called, completion of repairs deadline. We just put that in there for clarification. Okay. And then next is the RF 707, additional contract language. I would encourage everyone within the sound of my voice to utilize this form. These are, everything in this particular document is so critical. The verbiage has been studied and reviewed by our counsel, and we add to it as we see that there's a need. So if you're not familiar with the RF 707, take some time and really understand what is in this document, because it's easy. You can just cut and paste into the special steps if you need this verbiage. We made some changes on line 7, buyer's first right of refusal addendum. That's what we changed. We just changed the title.
It was really just a typo
Yeah.
that carried over from last year, because we had changed the title of the document last year and didn't sort of correlate it to the 707. So this is more of a cleanup change than a substantive change.
Yeah, yep. And then on page 90, item number 7, condominium information review period. I think it did say HOA review period. So for clarification, that's really a condo information review period, not the HOA. So we made that correction there. And I think that's it for that form. Yeah. Now we're going to the residential property condition disclosure, the RF 201. Who wants to take this one? We've got some changes, and the last couple of years, this form has been altered to more align with the state statute and what the statute requires. So, right?
Yes.
Okay.
Yes.
So, yeah, I thought you were.
No, what?
So, in these changes that we are bringing forth today is still trying to align this form with what the state requires. So on page 95, under C, line 113, we're taking out some things. that the seller has previously been asked to disclose. And we're taking out the methamphetamine, and any known or existing past or present mold.
And that isn't because we don't think these issues are important. They're
Right.
very important. And if you are selling a meth home, you as an agent have a duty to disclose that as an adverse fact and what has been done to that. They've just been removed because they're not listed in the statute. And we don't want to put in more of a burden on our sellers that's not there required by law. But if you are selling a meth property, again, that's an adverse fact. If you know of mold, that's an adverse fact. If your seller knows of mold, they need to disclose it, but they should really seek legal advice before filling out this form. But you'll see there that first section says, but not limited to, and that is a key phrase in that thing. So just because these things are being removed from the form does not necessarily mean that they do not need to be disclosed.
And would those things be covered under the verbiage environmental hazards? So that would
Yes.
include everything.
Right.
Everything that you're aware of.
So then agents should, during the listing appointment, just say, hey, if you know of any mold or any issues like that, please disclose that, even though it's not in.
My official answer is agents should direct all sellers to an attorney, particularly if they have questions about it. Do not provide legal advice to your clients. That's what gets you in trouble. That's when the seller discloses something that maybe was above and beyond what the law requires, and then they sue you. Or vice versa, the buyer sues them, and then you're sued. So to protect yourself, always direct them to an attorney. But I just wanted to make this aware that if you as an agent are aware of any of this and your seller does not disclose it, you need to disclose it as an adverse fact. So if your seller says, well, there's been mold, I'm a big fan of over disclosure versus under disclosure, but if they have a question, rather than saying, do I really have to disclose that, say, you need to speak with your attorney.
But they should disclose.
They should answer the questions that are on here.
Okay. Same with line 137. It references past or present interior water intrusion. That's not required, so we're taking that off. And again, if they do have knowledge of these things and they share that, we treat that with any other information that we are made aware. Line 145, we took tremors, windstorm, or wood-destroying organisms. Property or structural damage from fire, earthquake, floods, or landslides. And then we took those the tremor, windstorm, and wood-destroying organisms off. Line 186 is heating and air conditioning supply to all finished rooms. We took that off. That is not required by the state. Same with number 25 and 26, septic tanks, or if the property is in a historical district. Any questions about those changes?
So basically what you have right now is a form that is, that meets the form that is part of the statute. And we started the process last year, took out several things, and completed it this year. Because what is taken out here is not part of the statute for the seller to disclose.
Right, but that's not to overlook, there are other laws and other obligations of things that you have to disclose and this sort of thing. And I think Addison's comments were perfect. If these are sometimes very subjective answers you've got to come up with, and if you're dealing with a client that has to start asking questions, then that's when they need to be talking to an attorney on how they disclose things and what they should. Unless you follow Addison and my view that you over-disclose. But that's for your seller to make a decision, not us to recommend.
Was there liability involved with us having a more thorough property condition disclosure?
Not really. The statute allows, at the very bare minimum, the form that's, you can look it up with the state, okay? And it says, but it may include other things. So in the past, we've been including other things, but it seemed to grow. It was growing to the point that, where do you draw the line? How low is a hot water tank? Seller says 10 years old, you find out later on it's 12 years old. Is that a misrepresentation? Because the disclosure statute is very specific as to remedies if that's breached. There are other areas of law that you get into, whether it's a intentional misrepresentation or a lack of mutuality between the parties. So these other things fall in those other areas of law. So what we're trying to do is track what the statute intended for some very specific things. And we may have something else in there from time to time, but for right now, we're trying to get more aligned with the statute as to the property condition disclosure.
And
Yeah,
again,
because when we go in, we say to our sellers, this is what you have to do by law, and that wasn't true. We were going in and saying they had to, and yet the statute didn't say they had to.
And that was the issue that came to the Forms Committee a couple of years ago, is that real estate licensees, when they were going out and meeting with sellers, were saying the law requires you to make all these disclosures. And the seller's saying, no, it doesn't. It doesn't require me to do that. And they were right. It didn't require them to do that.
So we were kind of putting them in a more liable situation.
Yes.
Right.
I have a couple of questions.
and so there was a question from a YouTube viewer, and I understand the confusion, that says a seller does not have to, they said they were confused, that a seller does not have to disclose past, present water or mold, but you're saying that they do have to disclose. What we're saying is we have pared down the disclosure statement to what is required by the law, what the state requires a seller to disclose. And we just removed items that were not featured in that statute. Again, there's a whole nother case law, common law issues involved, and that's why sellers should consult with their attorneys before filling out documents. But if they have knowledge of something, then other laws may require them to communicate. But we want to remove liability from you as an agent, and so that's why we've just taken it down to what the state requires. So if you have a seller that's questioning that, direct them to their attorney. I don't know if that cleared that up, but.
Well, and when you're talking about mold, you're still talking about an environmental hazard, which is addressed at line 114. So we just
so
took
it's
out
not
the
listed.
specific question about
I mean,
about
both
mold.
of those topics are, you know, if
Covered.
you look paragraph 13, property or structural damage from fire, earthquake, floods, or landslides. I mean, we touch on, the statute touches on those issues. Before, I think we had gone back and tried to put a finer point on them, but in thinking about it, you know, we tried to go back to what the legislature said, this is what thou shalt disclose. And just leave it at that. And if they have an interpretation question, they can go consult their attorney.
Right.
So.
What about that other question?
Yeah. Yeah.
There's also a question about how to disclose adverse facts as an agent, and this just needs to be done in writing, signed by the buyer. And so there's not really a timeline as to when that needs to happen within the statute, but it's as soon as you become aware as an agent and your seller has not disclosed it, you need to disclose it to the buyer in writing. That's the important part, signed by the buyer, and make your seller aware before doing so that you are going to do it.
Wouldn't it be better to get the seller to disclose it if it's an issue?
Yes,
If they
but typically
want
it's
to?
the seller saying,
I don't want to.
I don't have to, and I'm not
And
going
I'm
to.
not going to, right.
So that's where you come in. doing
That gets dicey.
It gets very
Mm-hmm.
dicey.
Fiduciary responsibility.
If you
Right.
if you get in a situation where your seller's saying do not disclose it, but legally you feel like it's an adverse fact and you have to disclose it, that's where you really need to talk to your
Maybe a
lawyer.
Talk to your
maybe a
broker
time
and
that you
your-
terminate your listing.
Yes.
I mean, it might be
Yeah.
time to terminate the
And that's
listing.
where it gets, I've had that call a time or two, and usually the agent's been able to prevail upon the seller that, look, it's to everybody's advantage to go ahead and disclose it, let's do it, and explain how we resolved it and move forward, and then we all sleep well at night. But I'm sure there are situations where maybe a seller just really doesn't want to, and that's very unfortunate.
Okay. All good with that? Okay. I know these are gonna be, conversations that listing agents really gonna have to explain to their seller. And, you know, if you're questioning something, talk to your broker about that and get his, yeah, okay. RF 206, the lot land seller's property disclosure statement. Who would like to take that? Ron?
I'll speak up. It follows in suit with the conversation we just had about the property condition disclosure. The lot land disclosure, when you start looking to the statute of property condition, it speaks of residential properties. It speaks to a person's exempt if they've not occupied the property as a residence for the previous 3 years. So there are other things that a seller that owns land has to disclose in other methods and other forms, but not specifically on a lot land disclosure form specifically to that given statute. So the committee elected to delete that particular form. That does not mean that they still don't have things to disclose. It's just in other forms and other information.
Which is why you will not find that form in your booklet, because it's been removed from the forms library.
So you can stop looking?
Yeah.
Is there a
No need to
place-
panic.
Is there a place in here that says that's been deleted?
Yes,
In
so
the
the very
front.
first page. Page 1.
Page 1.
Line 206.
Yeah. Any questions about the rationale behind that? Okay.
So then did you put some of that in the lines? Well,
Yes,
in the
Bobby.
land lot listing, they have to disclose.
Well, that's exactly what the committee did, because there was all kinds of things there.
And
already.
this.
Yeah, okay. And then the last form we have is the RF 404, the lot land purchase and sale agreement. Ron, do you want to
Sure.
address that?
Primarily, some of the changes we made in the purchase and sale agreement just followed into here, such as Greenbelt. Greenbelt, once again, is just as important. I mean, it evolves from vacant land usually, but you have to deal with it both places when someone has a home with the property. But if you would turn over to page 104, you're going to see, really, go to page 103, I guess, so you can follow through. Down in section 8, you have the buyer's additional due diligence like you'd have in a purchase and sale agreement. But since this is land, when you go to 104, we've taken pretty much those same topics that the seller has a duty to disclose to also let the buyer know the importance of, just like letting them know the importance of having a home inspection. They may wish to look down at line 326, including the property being part of a plan unit development. That's where, it's a requirement that a seller disclose that, but also the buyer needs to understand these are things they might want to condition their agreement on, or their obligation to, once they have an opportunity to inspect that PUD documentation. Same thing with the toxic foreign substances. Buyer may wish to inquire or have the property inspected for underground tanks. The seller may not have any knowledge of these things, but it's good sense that if you're buying vacant land, there could be things. So you want to take steps to investigate. And then follow that through with land issues. At line 333, buyer may be interested in learning more about the presence of any field, mine shaft, well, diseased or dead trees. If something's important to them, they should be looking into it. And then finally, with that point there, is the rights and licenses. We don't see it much in the urban areas, but you get in the rural areas, you can have mineral right reservations, and that someone may not like to buy a piece of property that's got mineral rights reservations. Once again, these are additional due diligence. If you're selling inside a large city with residential homes, things about worrying about mineral rights is kind of insignificant. So that's why you don't actually see it over in the contract. But we try to keep that buyer on notice of things they might look for.
Is the buyer responsible to pay for any of that testing, just like it is on all?
Well, it's negotiable.
Same thing.
Yeah.
Always negotiable.
Yeah. Generally, it's, if you were throwing that in, it would be a negotiable item, but by the same token, in tracking with everything we've been doing up to the point, it's an inspection, and the buyers usually pay for that. But I think that's all it is for that form.
Yeah. We'll change on line 483, or references the binding agreement date. We'll make sure that that verbiage mirrors
Yeah.
the verbiage in the purchase and sale agreement. So, any questions about anything today?
I think you did beautifully.
Awesome. That's all. I mean, we've had an awesome year. I'm hoping that these changes will clarify and address some things that have needed to be been addressed. And again, if you have, as you're out there in the field, if you've got questions, if you've got concerns about any of the forms, feel free to call Allison on the hotline, and she'll address those issues. And that's all we have. It's been an honor this year to serve as chair. I think we've done some really amazing things. Thanks to the committee again, you guys were awesome. And to you guys up here, thank you so much for all your work and your help this year. So have a great rest of the year and look forward to next year and great things.
Thank you, Denise.
Oh, you're welcome. Thank you, Susan.